Hello everyone, today we'll be looking at the law on private nuisance. The last time we spoke, we looked at a very important area in the law on tort. We looked at the employer's liability to his employee. Today we'll be looking at private nuisance and what exactly is private nuisance and the characteristics that the court will consider in determining whether private nuisance is made out on the facts of any case. Now, for your purposes, there are two types of nuisance. There is private nuisance and there is public nuisance. Today we will be focusing on private nuisance, which concerns itself with the unreasonable use of a man's land to the detriment of his neighbor. And this was the principle laid down in Miller and Jackson. In order for a person to succeed in a claim for private nuisance, that person must show that he has sufficient proprietary interest to the land that is seeking to bring the claim against the adjoining owner, or that he has some beneficial interest in the particular land. If the person cannot establish that he has proprietary interest or a beneficial interest in that land, then he will not be able to successfully mount a claim in private nuisance and may have to resort to bringing a claim under other heads of the law of tort. Now, in order for a person to establish that he or she has a claim in private nuisance, the case of Malone and Lasky basically deciphers what does it mean to basically have proprietary interest in land. In that case, what was happening was that the wife of the adjoining owner was bringing a claim against the adjoining neighbor as a result of injuries that she had sustained from a cistern that had fallen on her head due to vibration from the adjoining owner's property. The wife's claim did not succeed when it was brought to the court on the basis that she was not able to show that she had a proprietary interest in the land, and as such, her claim failed. In the case of Bush, however, the law basically provided that that particular claimant had successfully brought a claim despite the fact that she was the daughter of the adjoining owner. What had happened in that case was that she was bringing a claim against the adjoining owner for harassment. Now, the law stated that she needed not to show that basically she had a proprietary interest, because the Harassment Act protected her against any form of harassment by a neighbor, and she need not show that she had a proprietary interest for the court to basically order that an injunction be put in place to protect her. In the case of Hunter and Canary Wharf, which is a very seminal case in the law on private nuisance, what was happening in that particular case was that the residents of a particular area were being affected, television signals was being affected by a construction of a tower that was taking place in that area. Now, the class of people that were bringing the claim were a mixed class of persons. So some persons were owners of land, while other persons were mere lodgers and persons who were basically paying rent at the time. The court basically stated in that case, in the Court of Appeal, that they could successfully bring a claim on the basis that they could show that they had proprietary interest in the land. However, in the Privy Council, they relied on the case of Malone and Lasky to say that persons who did not have sufficient proprietary interest in the land could not successfully mount a claim. The case of Malone and Lasky was, however, reversed on the basis that the wife had now succeeded in the case because she showed that she had some beneficial interest in the property that was owned by her husband. And as such, the injuries that she had sustained from the cistern that had fallen due to the vibration of the neighboring property, she was protected under the law of private nuisance in that particular regard. The law does not stop there. The law states that in order for a person to successfully bring a claim, then particular features would have to be looked at. They would have to look at the character of the neighborhood, the sensitivity of the claimant, and the duration of the nuisance. When we look at the character of the neighborhood, what we are looking at is what is reasonable in one neighborhood might not necessarily be reasonable in another neighborhood. And reasonableness here depends on the location that the incident occurs. Now, in order for us to establish that a person can successfully mount a claim in private nuisance, we would have to look at the particular activity that is being done and the type of neighborhood. If a person is doing steel work in an industrial area, then one could not argue that that activity is unreasonable. However, if it is being done in a residential area, then one could mount the argument that what is being done in that particular area has caused some amount of inconvenience, loss of sleep, loss of enjoyment to his land, and as such, that person who lives in that residential area could succeed in a claim for private nuisance. The law also states that the character of the neighborhood is irrelevant where physical damage is done to a person's land. And this was the principle laid down in St. Helens Smelting Company. Now let us move on to the sensitivity of the claimant. The law states that in order for a person to successfully mount a claim in private nuisance, the particular thing in question must not be unusually sensitive, or the practice or the purpose of the land must not be so unusually sensitive that disruption of any kind would be caused. If it is found that something is unusually sensitive, or the purpose of the land is unusually sensitive to particular things that would be done by an adjoining neighbor, then that person's claim may fail. And this was the principle held in the case of Robinson and Calvert. In that case, the law basically stated that they could not protect the claimant even though the heat from the adjoining owner's land had destroyed the paper, on the basis that the nature of the paper at the time was unusually sensitive. The court did not rule in the claimant's favor. Now finally, let us look at how long should a nuisance be present on a person's land for them to bring a claim. That the nuisance, according to the law, must be continuous. It must not be a one-off situation, or it must not happen at intervals. It must be continuous, means that it is present on the land without any form of interruption. If it happens today and it doesn't happen until the next 2 months, then it might be difficult for you to bring a claim in private nuisance. So, if you are thinking about bringing a claim in private nuisance, all the characteristics that I've laid out, you will have to put those into contemplation when you're making a decision as to whether you would want to bring a claim and whether your claim will be successful. The next time we meet, we will go further into other features that the law looks at when they are considering whether you can successfully mount a claim in private nuisance. Do not forget to like and subscribe. Have a superb week.